Welcome, and we have three wonderful papers from three colleagues of ours. Can everyone hear me okay? It's a little loud here. Okay, great. What I'm going to do is just do very brief introductions, as I understand is the custom, and then we look forward to hearing from each of the three panelists, and we'll just go in alphabetical order. So first is Rachel Bayevsky, who writes about constitutional law, federal court, civil procedure, and legal theory. She's an associate professor at UVA Law School. We also have with us today Nathan Chapman, who's the Pope F. Brock Associate Professor in Professional Responsibility at the University of Georgia. He writes about constitutional law, religious liberty, and ethics. And then finally, we have Catherine Mims-Crocker, who is an assistant professor at William and Mary. There she writes about constitutional law, federal courts, as well as local government. So if we can go just one by one, and so let's begin with Professor Bayevsky, let's hear more about her very intriguing paper, Contrition and Compulsion, Court-Ordered Apologies and the Constitution.
Thank you so much. Can everyone hear me, by the way? Great. Thank you so much to the conference organizers for putting this event together. And thank you to Smith in advance for his commentary, all of you for joining. So my paper is not, unlike those of the other panelists, about qualified immunity, nor is its topic limited to the federal courts, but it does address themes that relate to civil rights and legal accountability and the scope of judicial remedies. So in particular, my paper tackles the idea of court-ordered apologies and their relationship to the First Amendment. The subject of apologies is one that is familiar to all of us. We give and receive apologies in our personal lives. We also hear lots of calls to apologize in the public sphere, and we see public officials, including world leaders, issue apologies. But we might ask, what do apologies have to do with courts? So imagine a suit against state officials for denying a permit in retaliation for political beliefs, or a suit against a private employer who has been cheating employees out of their wages in violation of labor laws. If a court were to order a defendant to apologize in these scenarios, would that do any good? Would it even be a genuine apology if a court is ordering you to do it? And are there constitutional problems with ordering this kind of apology, such as apologies rooted in First Amendment compelled speech doctrine? So the idea of court-ordered apologies might initially strike some as kind of bizarre or even morally repugnant, and I'll suggest that the practice has more to tell us about our legal system and its underlying values than might at first meet the eye. So first, I'll highlight areas in American law where courts sometimes do compel apologies, as well as practices that might be understood as adjacent to court-mandated apologies. And second, I'll identify normative considerations bearing on court-ordered apologies. And then third, I'll examine the First Amendment compelled speech objection to court-ordered apologies. So with respect to the normative and constitutional dimensions, I'll argue that court-ordered apologies should not be rejected out of hand, that in particular, First Amendment compelled speech doctrine does not justify a blanket prohibition on the practice, and that instead courts and commentators should weigh the costs and benefits of court-mandated apologies in a contextually sensitive manner. But my primary aim is not actually just to defend court-mandated apologies. It's to show that normative and constitutional objections to this practice provide a window into challenging features of our legal system, such as the elusive ideal of voluntariness, the role of conscience, and the distinction between moral and legal redress. So to turn to existing practices, court-ordered apologies are not a particularly common remedy in the US, but there are certain pockets of law where they're employed. So in criminal cases, courts sometimes require the defendant to apologize as part of a sentence, including as a condition of probation. For example, Ninth Circuit once held a sentence requiring police officers who were convicted of perjury to publish an apology in the local newspaper in the police department's newsletter. And in the context of criminal sentencing, not many courts have addressed First Amendment objections, but those that have generally rebuffed these objections on the basis that criminal defendants do not have the same entitlements to First Amendment rights during sentencing. So that was the kind of reasoning that the state of Washington Supreme Court recently used in rebuffing a constitutional challenge to a court-mandated apology in a juvenile case in 2016. On the civil side, courts actually, interestingly, sort of fairly regularly order attorneys to apologize for their conduct in litigation. And perhaps most relevant to the concerns of this panel, parties have also asked for apologies in civil rights cases brought under 42 U.S.C. 1983. And most in the 1983 context, most courts have rejected requests for apologies on the basis that an apology is not a proper equitable remedy for a Section 1983 violation. So as one court put it, the law is not usually concerned with procuring apologies to make morally right a legal wrong done to the plaintiffs. And First Amendment concerns seem to lurk in the background of courts' rejections of apologies in the civil rights context, even if they're rarely tackled head-on. Beyond just the sphere of court-ordered apologies, there are what I call adjacent practices, where the legal system is kind of encouraging or incentivizing apologies, but the court does not ultimately order anyone to apologize as part of a judicial remedy. So some examples of this are that in criminal sentencing, judges sometimes give shorter sentences to defendants who express remorse. In restorative justice processes, offenders may apologize to victims as ways of acknowledging harm and laying the groundwork for moving forward. And some states have enacted apology shield laws that prevent apologies from being admissible in court in order to encourage settlement by removing a barrier to apologizing. What these adjacent practices suggest, I think, is that voluntariness is not a kind of on-off switch. It's more of a spectrum that a criminal defendant, for example, may apologize without strictly being ordered to do so as part of the sentencing process. But that person may have so much to lose if they don't express remorse that one might kind of question how voluntary the apology really is. And of course, these adjacent practices differ from each other. So you could say, well, as to apology shield laws, they would just remove a barrier to somebody offering an apology that they would have wanted to offer anyway. But the broader point is that our views on court-ordered apologies do not sit in a vacuum, that these views may have spillover effects for more commonly accepted societal practices. So having described the current landscape, I want to turn to a brief discussion of some normative considerations affecting the question of whether a court should compel an apology, and I'll just gesture towards them here. So some benefits of this practice might be producing vindication or a sense of satisfaction for plaintiffs, rehabilitation of the defendant, or the public reaffirmation of societal norms. Some drawbacks to court-mandated apologies from a normative perspective might be that it's degrading to the defendant, that it kind of conjures up socially detrimental practices. So it sort of reminds us of practices like forced confessions and public shaming, which we view as antithetical to a democratic regime. And that perhaps this practice might kind of siphon off energy for more meaningful reforms. So that's a brief enumeration of just some advantages and disadvantages of court-ordered apologies. One objection that I did want to address specifically was the idea of a sincerity objection to a court-ordered apology, that because a court is ordering it, it's not sincere, and therefore it undermines the ability of an apology to produce any of these benefits. And I suggest that in order for an apology to serve a social function, it's not clear that it needs to be sincere. So when the leader of one country apologizes to another for some kind of historical wrongdoing, the contents of that leader's heart are not necessarily critical. The point is that the world is bearing witness to the transmission of a certain message. So it's not to say that sincerity is irrelevant, but an apology that does not come from the heart might still be socially useful. So I turn finally to First Amendment objections to court-ordered apologies. And the point is to show that it's not simple to explain why these apologies violate compelled speech doctrine, because it's not precisely clear which values compelled speech doctrine protects. So the objection is the First Amendment protects not only the right to speak, but also the right not to speak. And if a court requires parties to apologize, that seems to be a state-sanctioned compulsion of speech, and also one that might implicate these core compelled speech concerns about the freedom of conscience. But if we think about, some of the interests underlying First Amendment protections, it's not so clear how to explain why compelled speech in this context is a constitutional problem. So, one interest that's often attributed to the First Amendment is the idea of promoting democratic self-government through the expression of a wide range of viewpoints. But it's not entirely clear how compelling a party to apologize in litigation after a judicial fact-finding process and process of the court coming to a decision would be a distortion of democratic debate. Perhaps, though, court-mandated apologies are more aligned with interests that relate to the violation of individual conscience that are often attributed to the First Amendment. So what might these be? Well, one idea is that a court-mandated apology interferes with the deliberative processes of the speaker. But in fact, a forced apology may not even affect the contents of the person's mind. It may also be problematic to require people to deceive others, to say what they don't believe. But if people know that the apology is required by law, it's not entirely clear the person would be engaged in deception. You might say that people have an interest in avoiding a disconnect between your thoughts and your words, to be forced to say what you don't believe. But that kind of disconnect might be sort of endemic to our interactions with others in social life. And it's worth considering if there are kind of limits to the value of authenticity. There might also be a sort of dignitary objection to being used as a kind of mere tool in the hands of the state. And I think this objection has some purchase, but there's also a need to consider if there's a sharp distinction between court-mandated apologies and other judicial remedies in this regard. So, for example, when somebody is made to pay damages, both to make the defendant whole and to send a broader societal message, why that does not involve, being used in some sense as a mere tool in the hands of the state. And then certain parties might have stronger dignitary or autonomy interests than others. So maybe there are weaker interests along these lines for government officials or corporations. So in terms of what follows from all this, in the end, the argument is that court-mandated apologies should not be met with quick rejection, either on normative grounds or on First Amendment grounds, and that instead it's worth considering whether the benefits of these apologies are greater than their costs in particular circumstances. And more generally, court-ordered apologies raise broader issues about legal practices that incentivize displays of remorse and about the relationship between individual dignity and public imperatives. I look forward to your questions and comments.
Wonderful, thank you. Now let's turn to Professor Chapman.
Thank you, Fred. Thanks everybody for being here. I'm really grateful for the chance to chat about this paper and to get your suggestions. It's, as you can tell, a pretty early stage, and I'm looking forward to hearing how I can improve it. So the paper takes as its impetus the fact that I think scholars largely agree that the justification for qualified immunity that almost all scholars focus on and that the court tends to focus on doesn't flesh out empirically. That justification is that qualified immunity is necessary for officers to not be over-deterred and the zealous enforcement of the law. And empirical study after empirical study calls this into a question. Now, I don't want to decide whether that's the case or not. I take it for granted that that rationale isn't sufficient to support qualified immunity. And so the question I pursue is, whether the court's other rationale for the doctrine, that it's unfair to hold officers liable in some cases, is a sufficient justification for the doctrine? And if so, how far does it go? So to answer this question, I dive into a legal theory, and I'll try to be brief with my discussion of the legal theory aspects of the paper. But I ultimately conclude that concerns about fairness sounding in the rule of law and deontological ethics do support some measure of immunity for officers from constitutional liability, but not nearly as far reaching as the current doctrine of qualified immunity. So to remind you, the current doctrine protects officers from constitutional liability when their conduct did not violate clearly established law of which a reasonable officer would have known. In practice, although the court has on a couple of occasions held that officers could be held liable where there was not a case clearly on point, in practice, it excludes liability unless there is a prior decision by the relevant authority, maybe the Supreme Court has hinted, maybe only Supreme Court decision, that is basically what lawyers would call on all fours with the facts of what the defendant did, which makes it extremely difficult to hold officers liable. This makes it hard to vindicate constitutional rights, to clarify constitutional doctrine, a whole host of things. And as most of you know, I'm sure the doctrine is under assault by both sides of the academy and increasingly suspect by members of the court. Nobody has really chased down this fairness or fair notice rationale that the court has consistently offered for the doctrine. I'm not sure exactly why. Some folks have focused on whether or not there's a good enough analogy to a fair notice doctrine in criminal law to justify it in qualified immunity, which is a similar set of concerns, but it doesn't really go to the heart of why there's a fair notice doctrine in criminal law for that matter. So it simply doesn't answer the question whether or not it supports all of qualified immunity today. So my paper sets out to try to do that. And it does so by setting aside, for the most part, utilitarian concerns. Most of those are the concerns associated with the over-deterrence rationale, and focuses on this notion that it's somehow violates the rule of law or is unfair to officers to hold them liable. It takes kind of as its paradigmatic example of unfairness or rule of law problems, the familiar example of a ex post facto criminal law or criminal punishment. But it gets really complicated really quickly because, of course, adjudications are not ex post facto laws. They're the application of existing law. And retroactivity of adjudication is kind of notoriously difficult issue in legal theory. It usually depends on resolving questions about what makes law, what makes it retroactive. And different theorists have tried to sidestep those issues in different ways, and I think some of them do so more successfully than others. I ultimately follow a path that I think Fallon and Meltzer kind of chart out a little bit in an earlier paper and argue that the touchstone really should be predictability. From the standpoint, I argue, somewhat against Fallon and Meltzer, from the standpoint of the subject, the person who's actually being subject to the law. So in this case, it would be the officers who are being held liable. So how predictable was the liability from the standpoint of the officer's conduct? And I argue that there are basically three broad categories of predictability. Those that are sort of pretty clearly unpredictable, where the court says, hey, we're making up a new law. This is a new rule. We're going to, oftentimes when the court does that, it actually says it's going to apply it prospectively. The classic example are new rules of criminal procedure. But it happens in other doctrinal fields as well. Sometimes the court overturns a prior decision. I argue that's pretty clearly a new rule. When the court applies a rule that had already been articulated for one jurisdiction and holds that it now applies to another. So when it decides that a doctrine under the Bill of Rights is applicable to the states under the 14th Amendment, whereas it had never held that before. So those are all examples of what I call relatively clear unpredictability. And then there's a ton of cases where it's pretty predictable, right? The mine run of cases never go to court because they get settled before because the liability is clear and the application of the relevant doctrine is clear. So those are the kind of the two poles. In between those poles are the hard cases. And in constitutional cases, these tend to come in two varieties. One is where there's a relatively narrow doctrine that is a relatively narrow rule that applies to the officer's conduct. And it will apply and prohibit the conduct with just sort of a minor stretch. It takes a textual stretch. You got to actually change the terms of the doctrine or create an exception to an existing doctrine, but it's not a whole cloth new doctrine. Another hard case, and I think that the hard case that accounts for the vast majority of difficult cases in real life are where the governing rule is simply relatively vague. It requires reasonable conduct. It prohibits excessive force, and we know what's excessive because no reasonable officer would apply that sort of thing. And it's in those cases where most of the applications of qualified immunity that I think many people object to tend to arise. And I say those are hard cases. They are not categorically either predictable or unpredictable. So what to do about them in particular? This is where the project frankly surprised me. I had thought going into it that in general I would be sympathetic to the officer's situation where there was the application of a vague standard by a court. I was persuaded though by some of the legal philosophy that I read, especially a paper by Timothy Endicott, which was not exactly on point, but kind of flirts with some of the same ideas. And there Endicott argues that a lot of the rule of law concerns and the fairness concerns, all of which arise from whether or not the law is sufficient to guide conduct. I mean, that's the underlying rule of law fairness problem, whether it can guide conduct. He argues that when a rule is even relatively standard-like, we might say, so long as the application of the rule follows from the articulated reasons underlying that rule, then it doesn't raise these problems of lack of guidance in terms of rule of law and fairness. I basically found that persuasive. And if that's the case, then a lot of these cases, I think, where it's a relatively vague standard being applied to officer conduct, especially in the policing context, a lot of times also in the prison context, the confinement context, a lot of those cases, I think, are what I might call predictable enough for purposes of the rule of law and fairness. So there's more to the paper. One thing I add that I don't think anybody's really thought about a whole lot, and I'm not sure is right, but I'd be interested in your thoughts about it, is this idea that we would be especially concerned where the retroactive application of a new rule entails a measure of public censure, especially censure for violating a duty owed to the public. That this might account for the intuition underlying the difference between retroactive criminal laws and retroactive civil laws. There's a pretty firm rule against the former in the Anglo-American tradition and in other civil human rights regimes around the world. Less of a strict rule against retroactive civil laws. All of this put together, I argue, by the time you look at constitutional law as a general rule, cases of course differ. Constitutional adjudications tend to be uniquely unpredictable for lots of reasons that I can go into if you want to in the Q&A, but the familiar reasons, right? We're especially in rights cases, we're talking about provisions that are relatively open textured. And whether Heller was predictable, whether Espinoza versus Montana was predictable, depends a lot on how closely you follow the court and the trends and the arguments in the court. So on the one hand, constitutional rules are pretty unusually unpredictable as a rule. They also raise a kind of unique, it's not unique to constitutional torts, but it is a relatively unique issue in legal theory. And I haven't found anybody yet who directly addresses this, although if anybody comes to mind, please let me know. And the issue is this, it's not just retroactive law when a new constitutional rule is applied retroactively. It's a retroactive law that also entails at least the appearance of a conflict with a prior duty. In the case of the officer isn't just free to act however the officer chooses. The officer has some discretion, but is generally obligated to enforce the law. So an officer who was, executing a valid warrant and enforces the District of Columbia rule that was later struck down in Heller, that officer had a duty to enforce the District of Columbia rule against certain kinds of handguns in the home, and holding him liable or her liable after Heller was decided conflicts with this prior duty, as well as being unpredictably retroactive. And then third, I argue constitutional liability comes with a kind of public censure that is unusual for private law. It's unusual for tort law. I do think it has some analogies in other kinds of maybe civil rights law, some kinds of anti-discrimination rules, but in general, it's unique for private law. And that means that the censure sort of has more teeth. It's more than just money payment, at least in the way that our society tends to think about and characterize what's going on. So if I'm right about those being the problems with retroactive constitutional liability, I argue, then qualified immunity makes some sense, where the law, what the court is doing is basically creating a new constitutional doctrine or enforcing an existing constitutional doctrine in a new jurisdiction, overturning a case, et cetera. It doesn't make as much sense, though, in a bunch of cases that it currently applies. So it doesn't make sense to apply when the officer acted in bad faith. An officer acting in bad faith is on notice that he or she could be held liable for violating the rights of the victim. It doesn't apply if the officer is if the officer's conduct violated criminal law, because even if it wasn't clear that the Constitution prohibited that conduct, the prohibition of the criminal law was sufficient to put the officer on notice that he or she would be subject to the kind of moral censor that we are concerned about in constitutional liability. And what to do about these hard cases, I don't have a slam dunk answer to the question, other than I think courts should be open to more rigorously enforcing the rationale underlying some of these doctrines. It's not clear to me that the reasonableness doctrine can get any narrower or more detailed than it is, which kind of creates a catch-22 for qualified immunity. But the reasons underlying the doctrine and the ways that the court has articulated the boundaries of the doctrine in certain cases, and I go into this more in the paper, should defeat a claim for qualified immunity. Doesn't necessarily mean the conduct was unconstitutional, but it should defeat the claim. So I spend more time in the paper talking about and trying to address counter arguments, and I'm happy to talk about those in the Q&A. But again, I welcome any and all corrections and suggestions you may have. Thank you.
Thank you. And then finally, Professor Catherine Mims-Crocker.
Awesome. Thank you. Thank you, Fred, for commenting on all these papers. Thank you to the organizers for inviting me here today. So I'm excited to talk about my forthcoming article, Qualified Immunity, Sovereign Immunity, and Systemic Reform. So I'm guessing that you guys were all already familiar somewhat with qualified immunity before you came here today, and you certainly are now after Nathan's excellent presentation. And probably you're especially familiar with the mass movement for qualified immunity reform that we've seen since George Floyd's murder. So my argument here is that focusing too closely on qualified immunity is a mistake, because qualified immunity is just one important piece of a much larger puzzle. So while individual accountability for constitutional violations is important, government accountability is important too, and in some respects, it's even more important. So in some ways, I learned this lesson by making the same mistake myself. When I went around presenting my first paper on qualified immunity a few years ago, it was in workshops like these and with scholars like you who pushed me to think bigger and broader, and I believe better. So the more I thought about all this, the more it seemed that in some ways, the problems with qualified immunity come in large part from the operation of sovereign immunity. And here I would include the Monell Doctrine that governs municipal liability, which Fred has astutely argued contributes to a form of local sovereign immunity. So my paper argues that doctrinally, qualified immunity grew out of sovereign immunity, and functionally, many of the arguments for reforming or rejecting qualified immunity point in favor of reforming or rejecting sovereign immunity in this context too. First, on a doctrinal level, the Supreme Court has been so protective of state and federal governments that the only parties it has allowed plaintiffs to sue are individual officials and local agencies. But even then, the court became worried that those parties could be financially devastated by defending against constitutional tort suits and paying constitutional tort judgments. So the court created, or at least strengthened, defenses for those parties. For individual officials, the court created and cultivated the super protective form of qualified immunity that we know today. It also made the circumstances in which plaintiffs can sue federal officials under the Bivens Doctrine extremely narrow. And for local agencies, the court said victims can only get relief for violations of constitutional rights arising out of official customs or policies, which has become a very high bar. So in the paper, I walk through a bunch of case law showing how all this unfolded, and I argue that besides trying to decrease defense side constitutional tort costs, the Supreme Court was also trying to decrease federal court caseloads. To be clear, I don't think that these are the only reasons that the Supreme Court has done what it's done in constitutional tort litigation over the last 50 or so years, but I think that these are important reasons. So moving from the first point about doctrine to the second point about function, my paper explores two areas where people have made arguments against qualified immunity and seeks to show that the same arguments work against sovereign immunity, maybe even better. So the first area relates to the impacts of indemnification. Led by Joanna Schwartz from UCLA, scholars over the last few years have shown that governments at all levels indemnify employees in constitutional tort suits almost all the time. Joanna found indemnification in over 99% of lawsuits against state and local law enforcement officers, and in over 95% of lawsuits against Bureau of Prison officials at the federal level, and over 95% of lawsuits there, but for over 99% of the dollars that were awarded to plaintiffs. So these findings have an obvious bearing on qualified immunity. The Supreme Court, as you know, Nathan has mentioned, has largely justified the doctrine of qualified immunity by saying it's necessary to prevent financial ruin for individual officials and negative consequences for the public, like disincentivizing people from taking government jobs or from performing those government jobs in a robust way. But to the extent that near universal indemnification prevents financial ruin for individual officials and these other kinds of consequences, we don't need qualified immunity to do the same thing. I argue that near universal indemnification should also be relevant to how we think about sovereign immunity. If governments are willing to pay these costs, we don't need to immunize them. And the current system of near universal indemnification has negative effects on the administration of justice and political accountability. Much indemnification happens in ways that are secretive or even illegal. So plaintiffs, judges, juries, and the voting public often have little idea that governments themselves are paying costs for bad actor officials. When it comes to the administration of justice, this system can have a wide variety of effects, from discouraging plaintiffs from filing suit in the first place to encouraging juries to limit the size of judgments. And when it comes to political accountability, this system can obscure the extent to which police departments and other public entities foster conditions that cause constitutional violations. The second functional area that my paper explores relates to the economics of unconstitutional acts. The starting point is that government conduct produces externalities. Qualified immunity essentially rests on the notion that individual officials should be able to reap some benefits of their positive externalities by avoiding some costs of the negative externalities that flow from their constitutional violations. The problem is that different parties are helped and harmed by these different kinds of externalities. The public at large benefits from the upsides of government action, but at least when it comes to the use of force, which my reform proposal focuses on, the evidence indicates that communities of color suffer from the downsides of police conduct at a disproportionate rate. So if we care about equality under the law, it doesn't make sense to require victims to subsidize the violation of their own constitutional rights by refusing to allow them to recover in constitutional tort suits. Some scholars have already made an argument like this with respect to qualified immunity, but here's where sovereign immunity comes in. If the public wants police and other officials to engage in actions that violate some people's constitutional rights, it should be up to the public to pay for them. The most direct way policymakers can accomplish this is by removing sovereign immunity and expanding entity liability. This would result in taxpayers going to fund the defense of constitutional tort suits in a much more open way than we see happening now. And it would hopefully encourage the public to reevaluate whether those costs are appropriate in the first place. The final part of my paper turns to how Congress could implement a system of greater individual and government accountability by removing qualified immunity, by scaling back sovereign immunity, and by creating legislative Bivens remedies. I propose that Congress should begin making these changes in the context of Fourth Amendment excessive force claims, and then use lessons learned there to expand reforms to other kinds of constitutional violations. One important part of my proposal concerns the substantive standard for entity liability. I argue that rather than making governments responsible for all constitutional violations, we should make them responsible for most constitutional violations, and in particular for ones that happen within the scope of an official's employment. This standard comes from the common law rule of respondeat superior, which of course holds employees and employers collectively liable for employee conduct that was more or less within the employer's control. Besides the usual theoretical arguments for respondeat superior in tort law, there are two main reasons why this kind of entity liability makes sense here. First, there are some situations where individual officials can violate people's constitutional rights under the state action doctrine, but where their conduct falls outside the scope of their employment. The main example is where police officers purport to exercise public authority while they're acting as private security guards. Here, the cost internalization arguments I mentioned before don't apply because the official isn't even engaging in the government job that the public wants them to perform robustly in the first place. Second, holding governments liable for conduct that occurs within the scope of employment seems to align relatively well with real-world indemnification patterns. So to the extent that we want legal doctrine to match on-the-ground realities for reasons related to the administration of justice and political accountability, respondeat superior provides a pretty good model. Finally, I touch on the possible consequences of my proposal for three issues that scholars have raised. First is fiscal concerns, second is caseload concerns, and third is rights-based concerns. So we can look at these issues through the lens of remedial equilibration, which addresses how doctrines defining causes of action, defenses, remedies, and the core of rights all interact with each other. We can't predict what would happen if we made these reforms with complete certainty. It's an empirical question, as they say. And it's important to emphasize that there would be some important differences from the way that things work now. But there are good reasons not to be too worried that catastrophic financial or caseload consequences would flow from making the changes I've mentioned. And the same goes for questions about whether courts would constrict constitutional rights if they knew that greater liability could result. All of that is especially true in the excessive force context where I advocate beginning the reform process. So that's in part because governments are already paying the costs of these claims through other avenues to entity liability oftentimes. It's in part because the merits criteria already allow courts to make flexible reasonableness determinations, and it's in part for other reasons. So I'm grateful for any guidance and thoughts that you all have. In particular, I'm wondering whether framing the focus as qualified and sovereign immunity obscures the importance of Monell doctrine for municipalities. And sort of a smaller part of that question, whether I should change the title at this sort of late point in the process. I see Fred thinking about it, which I really appreciate. And I'd also love to hear any ideas that people have for using this work as a jumping off point for future projects. So with that, I'll turn it over to Fred, and I'm really happy to hear everyone's questions and comments.
Great, wonderful. Thank you for those three great papers and descriptions. I'm not at home, and my internet it will go out just based on the last hour or last 45 minutes. It's going to go out at different moments. And so when that happens, just let me know and I'll pause. And but I also now know from the last hour that it'll come back. So let's begin with this intriguing paper on apologies. What we have here, I really love the way that you approach this, both from the perspective of the perpetrator and the survivor, right? And kind of really dive into ways in which an apology can be about both, right? An apology can be about rehabilitation, for example, which is about the perpetrator. An apology could also be about the survivor, and that's broadly defined as you define it, to also include people who may not have been directly harmed, but kind of society more broadly, in this kind of more general way. And you also note something of a caution implicitly as you describe different cases in which rehabilitation is the rationale, or rehabilitation crosses over in some instances into something much more sinister, like shame. One thing I did find myself wondering is the definition of apology, and whether or not you want to really kind of provide one, and what you mean, and what the kind of constitutive elements of an apology are, and or different types of apologies. And part of what made me think about this is when you describe a case where a court says, from a First Amendment perspective, I'm not going to tell you the content of your apology. You can apologize, and can you hear me? Okay. You can apologize in lots of different ways. Actually, sorry, this was one of your Fifth Amendment cases. You can apologize in lots of different ways. You can apologize by saying, I'm sorry I made you feel that way, right? And an apology of that sort, right, it's hard to know whether or not that really is doing anybody any good. Is that doing the perpetrator any good? One could certainly make the argument that it might make things worse for the survivor to have someone come into court and say, I'm sorry that I made you feel that way, right? And so kind of thinking about what makes something, an apology, worth enforcing and worth demanding, or different types of apologies, and the ones that we respect and the ones that we want to be more cautious about, I think could be helpful here. That might also push you to think about whether or not you're only concerned about apologies. And I suspect you're not. I mean, it's based on your prior work and based on where it seems like this is headed, you're interested, and based on our conversations outside of this forum, I sense that what you're concerned about is it's more broader questions about dignity, right? How do courts redress dignitary harms when courts have so few remedies at their disposal to actually do so? And because one of the areas in which I write is about the rights and interests of people who have passed away, it called to mind cases like one in North Georgia, where really grisly facts, a crematorium was not actually cremating bodies. A person took charge of it who didn't have, it was his father's business. He took over, didn't have any knowledge about what he was doing. And anyway, I won't go into all the details, except to say that at the end, one of the remedies that the court gave was demanding that he fund a memorial. And so there's a memorial on the site where this took place to commemorate the hundreds of victims. And so I was saying this to a friend over dinner, talking about your paper, and they said, well, isn't that a type of apology? Right. And I was like, well, it depends what's an apology. Anyway, so yet another reason to kind of, if you think about what it is about an apology that you care about, there might be other remedies that might that might bring into the paper and make it even richer. On the sincerity point, and this goes back again to making sure that the survivor's dignity is being honored and respected. Yeah, I'm persuaded by all that you say about since about reasons why we may not be that concerned about the perpetrator when it comes to sincerity. But I do think if the goal here is to honor the dignity of the victims or the survivors, then sincerity might matter more, right? And it's kind of forcing an apology that is just transparently not sincere might actually do more harm than good as well. Next, this is just I mean, take it or leave it. Well, I guess all of it's take it or leave it. But on the framing, when I got to the part of the paper about courts rejecting apologies with these really strongly worded statements about how that's beyond the judicial power and so forth, and statements that if one just read that case, one might walk away and say, oh, okay, yeah, I guess that's beyond the judicial role, except that in reading your paper, we've just encountered all of these examples of courts doing exactly that. From a framing, you may consider leading with that so that you have a foil, right? Leading with these really strong statements from courts saying that this is beyond the judicial role and this being sought. But hey, look, actually, there's lots of settings, right? And you might consider using that as your foil. And then relatedly, I did find myself wondering, it sounded like from your paper that it's civil rights cases, and especially civil rights cases that involve questions of identity, where courts are particularly skeptical of these remedies. And you say that, but I might invite you to think a little bit more about why that might be, and to take a more critical lens with respect to that to those cases. All right, next, Professor Chapman. So Nathan, this is really interesting. You note that there's a lot of scholarship out there that doesn't really so much focus on fair notice, instead focuses on deterrence. And you do a good job of noting that is the primary rationale. So you don't overpromise. You say, look, that's the primary rationale of Harlow versus Fitzgerald. But you say that's not all there is to the story. Look at all these other cases, and you have that big thick string cite of all the moments in which courts also talk about fair notice. A few thoughts. One is who this is addressed to, in the sense, like, is this about what Congress should be doing or what courts should be doing? If it's about what courts should be doing, then still kind of lingering in the background is the Will Bode idea that qualified immunity is unlawful in the first place. And so, I mean, to the extent this is pitched to Congress more, then that matters a little bit less. But to the extent that you're saying, this should inform the future scope of the doctrine, when at least among justices on the right, to the extent that they've expressed skepticism, it's kind of been more of a formalist argument. It hasn't been so much about the deterrence policy arguments as it's been about the lawfulness of qualified immunity at all. On bad faith, I might push you to think a little bit more about and tell us a little bit more about what bad faith means. If someone is acting in a way where they know that what they're doing is unlawful, but they don't know what they're doing is unconstitutional, for example, what should we do with that, right? I think about cases in which people have been criminally indicted, but were entitled to qualified immunity, like Plumoff versus Ricard, right? Officers criminally, they had enough notice to be criminally indicted, but not enough notice when it came to qualified immunity. I also think about a case that you cite, Mullenix, where we learned, especially in the dissent, that the officer, before engaging in this deadly force, said that we know that he was told not to do it, and he did it anyway, with the snide remark, how's that for proactive? Is that bad faith? Like, I mean, how do we, I mean, so these are moments in which we know that the person knows that what they're doing violates the law or violates some sort of command, but maybe they don't know that it violates the Constitution. Also, bad faith, right? Subjective bad faith was rejected in Harlow versus Fitzgerald. And so do you really mean to be inviting all of that back? And if you do mean to be inviting all of that back, then I think dealing with lots of concerns about what that means for discovery, what that means for many trials before the trial, et cetera, et cetera. If you're making that claim. So my next points really, they kind of go where Catherine's paper went in some ways, which is how does this interact with a broader system of constitutional torts, right? Because this matters less if there is entity liability. So how does this interact, for example, with indemnification? And how does this interact with entity liability? And how broad do you mean your argument to be, right? So there's a version of this Jeffrey's approach. There's a version of this argument that doesn't just apply to qualified immunity, but that would also apply to entity liability too, right? So, if you're right that we should be really skeptical of the retroactive application of constitutional rights, or at least more skeptical than we are in this setting, then isn't that a story not just about this one specific doctrine, but isn't this a story that runs with I almost called it local sovereign immunity, but with municipal liability and with potentially with state sovereign immunity as well. John Jeffries in his paper, a theory of constitution, a fault-based theory of constitutional liability. I'm butchering that, but in the Virginia Law Review from 2012, and that title is roughly on point. That he says, look, for some of these reasons that you point out, actually, the standard should be fault. The standard should be notice across the board, and these distinctions between individual liability and entity liability don't make any sense. And so I think your paper is enough in that space that it would be helpful to engage that set of questions. You talked some about Teague, and and this is a question that I've gotten when I've written some about notice. It's this difference between something being a new rule altogether and something being an application of an old rule. And you already engaged some in that literature, but I think you can continue to. And I think you have a good point that sometimes there's just an entirely new rule. Sometimes something may not be unconstitutional at T1 and becomes unconstitutional at T2. I'll quote from Shelby County versus Holder. The question is whether the Act's extraordinary measures, including its disparate treatment of the states, continue to satisfy constitutional requirements, suggesting that at some point they did, and then over time, some set of circumstances changed, and something that was constitutional became unconstitutional. And so, to your point, right, that would seem odd under those circumstances to have a really heavy hand. On the other hand, right, where there's an old rule and there's application of that rule, right, then that's gonna potentially take us to a different place. And you already engage some of that, and so that's just me expressing some sympathy with the idea. I think this goes back to the entity liability point. It's hard to balance how much one should care about fair notice without knowing whether or not there'd be some other. So if this is about notice versus accountability, for example, then on the accountability side of the ledger, I think if we were formulating a system of constitutional torts, then we would want to know more about what other avenues for accountability there are. So your paper could go in lots of different directions there. And so, I look forward to, if you take these invitations, I look forward to seeing where it leads you. All right, next. So on this last point, yes. So Professor Crocker, yes, I think you do a really good job of actually making clear that the qualified immunity is a part of a broader system of constitutional torts, and you dive in really well when it comes to important technical details of this nuanced doctrine, but then you also zoom out enough to show us how constitutional torts operate as a whole. And you're asking big questions like, how do we build a system that deters illegal acts, that compensates victims, that fosters systems perceived legitimacy, and that's mindful of the complex interplay between rights and remedies. And you note that to do any of this well, we have to look beyond any specific remedy. We have to look to things like state sovereign immunity. We have to look to things like local sovereign immunity, and we have to look to how qualified immunity, how various immunities interact with one another. And we have to think about insurance and indemnification, right? All of that's on the table, and you don't shy away from it. You dive directly in on all of those fronts. And I mean, I think you're right that abrogation of sovereign immunity is possible here. So even if 1983 is currently situated, doesn't necessarily abrogate sovereign immunity. If this is aimed and pitched at Congress, it's pretty clear, I would think, that saying that you can hold a state liable when there's a violation of the Constitution would be kind of as congruent, as proportional of a remedy as I can personally imagine. And then there's this pragmatic tone that your paper also takes, where you're trying to figure out what moment we're in. And this is true of kind of your most recent work, trying to figure out where are we, right? Like, are we 2 summers ago? Or I mean, how much of that is still here? Like, are we already in retrenchment land? Like, and you're trying to write remedies to the world that we actually are in at this moment, which is not the only way to write, right? I mean, one can write to the world as it might exist in 20 years, or one can write in a way that tries to really push and reshape what moment we're even in, et cetera. But that's the about it. I would say that the paper could be aided at the outset by stating what your principles of accountability are. So what are the principles that are most important to building a system of constitutional accountability? And at present, what's missing, and under what circumstances are they missing? And some of those questions are answered implicitly as the paper unfolds, but stating them more at the outset could make more apparent the value of your solutions. And it also might bring into sharper focus the reason for your kind of, I'll call it excessive force exceptionalism. Because in this paper, you kind of invite kind of a, maybe at least initially, and this is part of your pragmatism, a different rule for excessive force than for everything else. But is that just pragmatism? What are the reasons why excessive force is the most urgent issue of the moment, and why? What justifies tailoring a system of constitutional torts to that very specific harm? John, you get actually some. John Jeffries gives you, takes you part of the way there, because in his paper, he also at the end says, now look, excessive force, at least in the Fourth Amendment context, is its own beast. And, you know, but part of why I think it matters is because you cite to some of the cases like Jessup versus City of Fresno, which has become sort of a number of some people's, it's my go-to when I'm talking to an audience about qualified immunity and the direction that it's gone, and just for everyone's benefit. That's a case where officers stole hundreds of thousands of dollars, but they had a lawful warrant when they seized the money. But then, and so the question was it an unreasonable seizure given that they kept the money after their lawful seizure? And the Ninth Circuit said they were entitled to qualified immunity because there were no cases saying that that this kind of after the fact keeping of the money was an unreasonable seizure. And they said that there were no facts, there were no prior cases to say that this violated substantive due process either. And so this, I mean, a rule that engages in this excessive force exceptionalism is going to leave, you know, significant breaches of the Constitution and of the public's trust on the table. And so, you know, if this is the moment, and I'm not sure that it is, but if this is the moment now for real true reform of a system of constitutional torts by Congress, then you know, do we want to leave those kind of breaches unredressed, not knowing when this moment might come, or any moment like it might come again? All right, so those are my comments. And so is the norm now that we go directly to questions, or is it that you respond to what I said.
I think either is fine. And other panels, the presenters have responded briefly to the
Okay.
comments.
Great. Well, let's do that. And then there's already a queue developing. So either direct message me or raise your hand. And before that, if we could hear from the three presenters in order. And so let's start with Rachel.
Great, thank you. Well, thank you so much for those comments. I think they're really spot on. So about the definition of apology, I completely agree. This is something that needs to be fleshed out. In fact, I think that part of the problem is that when we think about apologies, we may have in our head a certain version of what a genuine apology is that's rooted in kind of personal life and, let's say, close friends reconciling after they betrayed each other. And so we might see other apologies as kind of falling short if they don't meet that model, namely apologies that are primarily social acts between people who don't interact who interact only at arm's length. Professor Chapman also helpfully noted that there might be a kind of, to me earlier, that there might be a kind of distinctive type of apology that's a kind of representative act on behalf of others. So that might explain part of the world leaders apologizing. And for all of these types of apologies, one might ask, how important is acceptance and responsibility? Thinking about what are the prerequisites of apology, I do think that seems like an important one. And I think possibly even more important than even having emotional attitudes that we might consider characteristic of an apology, like a subjective sense of remorse. But in general, I really agree that it's important to flesh out this point. I also completely agree about other remedies that might help to restore dignity in addition to apologies. And in general, I'm advocating a kind of creativity about courts' remedial authority, that thinking about what is needed to make parties whole, if that's really a goal of remedies, and to the extent there are objections, including constitutional ones, to do what's needed to make parties whole, making clear that judicial remedies in an important sense fall short. The sincerity, there's an interesting dynamic sometimes where it's kind of, it may not be critical if the apology is in fact sincere, but it would be problematic if the person making the apology outright says, I apologize and I'm not sincere. But I'm not sure. I mean, there's a recent case where a South African judge was required to apologize for some remarks that he made by a panel that was governing judges' conduct. And he said, I am now forced by the law to apologize unconditionally. And so there's a question of whether that kind of apology, might have an effect. And then on the framing point, yes, I very much agree. And the comments, Aaron Nielsen also sent me a helpful case where DC Circuit judges are strongly taking issue with a kind of notice reading requirement in administrative law setting. And I think emphasizing some of that language might provide a useful foil. So thanks very much.
And Nathan?
Hey, thanks very much, Fred. So I'm addressed to both the courts and Congress here. I actually think I don't have space to do this in the paper, but I think that the revisions I'm proposing to qualified immunity actually make it much harder for Will to maintain his case. So like in other words, if the court were to adopt my proposed revisions, it would look a lot more like common law defenses that existed in the 1860s. And so, and he, his primary response to the analogy to fair notice in his paper is to say, well, fair notice doesn't go nearly as far as qualified immunity. He didn't tease that out, and he didn't get to the bottom of the sort of legal philosophy underlying it. But I do here, or at least I try to. So I actually, it's another paper to weed through the history and make that case. But I don't think Will's paper defeats the version of liability, qualified immunity I'm proposing. I'm thinking that looking at bad faith would be a total sea change in the way these cases are litigated. And I addressed the fact that would cause a lot of collateral costs on district courts, especially, and litigants, including defendants who did not act unconstitutionally and who are protected from that litigation under the current regime. But I think I don't think that the fairness rationale justifies letting them avoid that. Maybe that's where over-deterrence and utilitarian concerns steps in to say we shouldn't do it, but I'm doubtful. Yeah, I think you're right that this has implications for institutional liability. In the paper, I spend the last 3 or 4 pages talking about applying this to institutional liability and rely on John's paper. Also talk about the possibility of applying this version of qualified immunity to contractors who currently do not enjoy any qualified immunity. So that would be one place where liability might actually be reduced as a result of my proposal, but I think the fair notice rationale would extend to them. Oh yeah, the new rule versus the application of an old rule is kind of the sticky booger of the whole legal theory section, and there's I'm not sure there's a totally satisfactory answer to it, but I do think there are plenty of cases where it seems clear that there's a new rule where enough lawyers would say, well, you're changing the words of the rule, or you are saying that the rule now has a new rationale that it did not have before, something to that effect. Yeah, that's it. But thank you very much. Really helpful.
Catherine?
Yeah, thank you so much for those comments, Fred. I guess to address the excessive force exceptionalism point, which I love that phrasing that you're using. I guess this isn't the only reason why, I take that position, but one important reason why I take that position is because a lot of the empirical evidence that has been gathered relates to either the law enforcement context in general, or this isn't empirical, or excessive force in particular. And so I'm thinking of, Joanna Schwartz's work on indemnification. It relates to law enforcement, prison officials, and she's talked a little bit about how, there's not great reason to think that other kinds of government officials are indemnified less often. But I just don't think that we know that as well. So I worry about I think in theory, there's good reasons to think that we should have entity liability across the board. But in terms of thinking through the actual practical applications, I worry a little bit that we don't know as much what's happening on the ground in other areas. So that relates to law enforcement generally. Excessive force in particular, I think one big important part of my argument is that governments are often already paying for excessive force claims. They're just not doing so under the framework of the federal constitution. I think it's important to add federal constitutional liability, but through common law tort regimes, through the Federal Torts Claims Act and stuff, the law enforcement proviso makes it so that excessive force is something that in that sense that the federal government's already paying for. And so I think that the financial implications, that they could be meaningful here, but that there's good reason based on things we already know about how things are happening on the ground, that they wouldn't be catastrophic. And so that's one reason why I focused on that area. And yeah, so I want to think through it more, but just to sort of flesh that out a little bit. I also just, maybe we can connect sometime off of this Zoom conference, but I'm really curious to hear sort of if you would mind elaborating on what you mean about stating what principles I'm using to, what principles I imagine being important to a system of accountability, because I think that that's important, and I would love to respond to that concern more in the paper, but it might be helpful for me to hear more about sort of what you're thinking of.
I look forward to that conversation.
Thanks, Fred.
And so the first question is via the private chat, and it comes from Nathan.
I'm going to pass so other folks can talk. I've talked enough. Thanks.
Next is Laura.
Hi, this is a question for Rachel. I really enjoyed your paper, and I'm wondering whether you've thought about framing these apologies as incidental regulations of speech, sort of in the line of the NIFLA exception for informed consent laws. It seems to me that you're sort of arguing that First Amendment principles don't apply because these aren't really traditional speech regulations at all. And I think this might be a helpful question to ask, whether these are incidental regulations, because whether something is an incidental regulation often depends on the government's goals. And so I think maybe the goal of an apology might be a way to determine whether it's really implicating the First Amendment in a way that requires this really heightened kind of scrutiny, or whether it's not really implicating the First Amendment in a traditional way at all.
Did you want me to respond now, or did you want to collect questions?
Yes, if you would like.
Oh, sure. Yeah, I'll just, yeah, so I think that's a really interesting point. And I, you know, thinking about which doctrinal category a court-mandated apology might fall into, you know, it might depend to some extent on who's the actor that's being required to apologize, in particular, whether that's a government official or an individual. It does seem like something about, you know, being forced to say something by a government institution that is a court, and to say something that is so close to the traditional areas of, you know, what people personally believe about their conscience and or about their conduct. And it seems to strike a little closer to the type of conscience-based reasoning that the Supreme Court used in cases like Barnett and Woolley. And so you know, there might be sort of pushback on viewing this as just an incidental regulation, but I think it's certainly something worth considering.
And next is Professor Harold Pratt. Yes.
Yeah, you know, thanks. I have a question for Catherine, which is, I think much can be gained by comparing qualified immunity and sovereign immunity, but I do think you should keep in mind that that the qualified immunity as it's evolved is common law based. It's changing, and I think the underlying rationale, at least I think, for federal sovereign immunity is the separation of powers of who makes the rules, Congress versus the courts. So and the fear of judicial usurpation, and I think both Nathan's comments and your comments suggest that courts have done a lousy job. So as you just compare, I think that sort of difference sort of setting a little bit, that one may be constitutionally based and the other we say, oh, of course Congress has the power to, you know, overcome all these judicial doctrines that have emerged, might be helpful in contrasting the two.
Yeah, I really appreciate that. I'll keep that in mind. Thank you.
Are there any other questions? All right, we're at the end here, so we're I mean, we have 2 minutes. I'll say one thing. Nathan, one thing I meant to say with yours is in some ways you're writing to this. I think there's already multiple qualified immunities out there, right? There's, I mean, Hope versus Peltzer and its articulation is different than Anderson v. Creighton, right? Hope versus Peltzer is a fair notice standard, and Anderson versus Creighton has much stronger language. And I think there's kind of this parallel world that some circuits live in where they rely more on one than the other. And you're inviting kind of embracing one version of that. And that might be one framing piece. All right, thanks so much for everyone. This was a lot of fun, and enjoy the rest of the panels and your day.
Great. Thanks so much to Professor Smith, Bayesky, Chapman, and Crocker. And good to see all of you on here.
Thanks so much for having me. Thanks, Fred.
Yeah, thank you, everyone.
See you in the breakout or in the plenary.